professors, but I know this is a survey course, PSC 120, it's a required course for everybody at the university to take. But nevertheless, I want you to understand you have at least one professor that is open to you. So I just want you to know that I don't want you to sit on anxiety or feel like it's a hopeless cause. I mean, I want to be a part of that with you. So just believe me when I tell you that. Okay, I think we were getting ready to go into this chart on Wednesday, and we didn't quite get there, but we're going to take kind of a relaxed approach on Chapter 4. We'll finish this up on Friday, so hopefully we'll get through it. There's a lot to Chapter 4 with regard to the whole discussion on civil liberties as it pertains primarily to the Bill of Rights. Freedom of speech, there's pure speech versus symbolic speech. Not all speech is created equal. There's unprotected speech. Like I said, there's some things that you just cannot say. And I use the example, for academic purposes only. You can't say, I'm going to go shoot the President of the United States. You just can't say that. Because like I may have said on Wednesday, you will have people showing up at your doorstep wearing sunglasses and a wire extending from their ear, and they will be there to visit you if you say something like that. So there are certain things you can't say. Members of Congress, on the other hand, can say anything they want while Congress is in session when they're on the floor of the House or the floor of the Senate. They can say that it's completely protected. No retribution. Nothing. But most of them are very careful about what they say because the C-SPAN cameras are on them. But before C-SPAN showed up in Congress in the late 70s, members of Congress would say a lot more than they say now because they realize they're being recorded and people are watching them. So, but nevertheless, the rules have not changed for members of Congress. They can still say anything they want to. And there's freedom of the press. We'll jump through that here. Freedoms of religion, privacy, and criminal process. The First Amendment and the freedom of religion. Well, we go to the First Amendment, and they have a very specific use of words. I mean, these words, every one of these words in the Constitution and in the Bill of Rights were included after a painstaking debate. Every single word. And so, if you go to the First Amendment, you'll notice that Congress shall make no laws respecting an establishment of religion. That is what is otherwise known as the Establishment Clause. Government, U.S. government, is not going to be in the religious business. And so we're not going to have a state-sponsored church. The United States government cannot be connected with religion directly. And so that's what's referred to as the Establishment Clause. Or prohibiting the free exercise thereof. That is what is known as the Free Exercise Clause. In other words, you have the freedom to exercise your religious beliefs as long as it doesn't infringe on somebody else's. It's disruptive or whatever the case may be. So these are included in the same part of Amendment 1, the Establishment Clause and the Free Exercise provision. And of course, we all know that for bridging the freedom of speech, there's the first element, there's 5 of them. Of press, there's the second, or the right of the people to peacefully assemble, 3. To petition the government. And so we've got religion, speech, press, assembly, and petition. So we got all 5 of them. But the free establishment clause is in the First Amendment to the Constitution, and the free exercise clause is there as well. The right to privacy, the emergent right to privacy, is applied to other activities. We're going to get into the right of privacy when we talk about the 14th Amendment, which is just outside, obviously, the Bill of Rights. The Bill of Rights includes the first 10 amendments traditionally, but the 14th Amendment has become a very powerful amendment with regard to right to privacy, namely a woman's right to privacy in the case of Roe v. Wade back in the early 70s. Freedom of speech, still within the First Amendment to the Constitution. The Supreme Court has refused to protect speech that it considers obscene, defamatory, or constituting what is called hate speech. So that basically, that presents a danger in the minds of the court to society if you use such speech. And so that basically becomes a clear and present danger test. Prohibits only words that produce both an obvious and immediate danger to the community. Legitimate questions exist about what constitutes political speech and about the extent to which it is protected. When you're a candidate running for office, you're going to probably be making accusations against your opponent. Well, it's kind of a fair deal. You better, like I said, you better be willing to understand what the things are in your closet if you're running for office, because your opponent is going to expose them. They may expose things that are not even there, but that's just the normal course of running a campaign. So political, that's kind of in the public venue, if you will, as opposed to committing slander or libel. We'll talk about that in a few minutes. The Supreme Court has upheld limits on political contributions, but ruled that restrictions on expenditure violated free speech guarantees. During the President's State of the Union address in 2010, just a week before, the U.S. Supreme Court basically said to restrict the contributions that a corporation contributes to a political candidate's campaign is a limitation on that entity's freedom of speech. Well, the Democrats and the President didn't like that decision. And so the following week, when they had the State of the Union address, we had justices show up. And of course, there's 3 branches of government represented at the State of the Union. They don't have to be, but traditionally they're there. You had the Senate and the House. You had the Supreme Court justices, and of course you had the cabinet there and other members of the administration. And basically he admonished the justices right in front of everybody on how much he disagreed with that, and all the Democrat senators and members of Congress stood up and started heckling the justices and clapping at them and laughing at them and everything else. It was quite a spectacle. Even the liberal justices on the bench, like Ruth Bader Ginsburg, Sonia Sotomayor, and others, found that appalling, that one branch of government would admonish another branch of government in such a way. And it was all based on the court's decision the previous week on this matter here. Do you think, what do you think? Do you think a corporation ought to be limited or be able to give as much money as it wants to a political campaign based on some First Amendment right that it has?
No.
You think it ought to be limited?
I think it ought
Do you
to
think
be
the campaign contributions ought to be limited?
Yes, because of companies such as Monsanto, yes, I believe that they are lining the pockets of our politicians. And then when our politicians aren't politicians, they go work for them. Mm-hmm. So they line their pockets even more. I think.
And you don't think you have an equal opportunity to do that? So it's a matter of their wealth versus your wealth.
Mm-hmm.
And so the government should level the playing field, or the Supreme Court should level the playing field.
Well, I think if they have that much money, they need to be putting it towards something else, like research of how not to toxify our world.
But let me play devil's advocate. I'm not saying I agree with you or disagree with you. Who are we to tell a corporation what to do with its profits? as long as they're using those profits for illegal purposes.
I guess we're not because of free enterprise.
So that's the counterfactual, right?
But there's just too much, there's too much tit for tat.
Well, let me ask you this question. I hate this example, so bear with me. How much money would it take you, would it take for you to side on a certain position that maybe you wouldn't otherwise side for? In other words, how much money would we have to contribute to your campaign? $1 million? If somebody contributed $1 million to your campaign and you could use $1 million in your campaign war chest, if someone magically wrote you a check for $1 million, would you consider siding with them on issues that were important to them?
For me personally, no.
Anybody else? Would anybody in here do that? Well, I'm glad to see that. I'm glad to see that response. Seriously. It leads up to my point. Because obviously you wouldn't do it for $100 either then, right?
No, but
So we're just negotiating the
But the
price.
politicians and the political actors are not like this class.
Well, I don't know about that. That's a normative statement to make.
Some of
I'd hate to try to prove. But let me make a point here because you bring up an excellent point. Political scientists like me, political scientists who do hardcore research on political actors have never been able to prove with a solid line that if they receive certain amount of money into their campaign from an entity or an individual, that they will vote that way. No one has been able to ever prove that. But the perception is that's what's happening. But no one can prove it.
Have you ever...
Because if you can prove it, it would be called bribing.
Right, but how can you not say they're not... When you look at Monsanto's upper echelon...
Because that's our disgusting perception of the whole process as people that are set back.
But when they
casually
vote,
observing.
when they let genetically modified crops, just, it's all right, go ahead. They just sign away the bills. They make it... They deregulated it.
Yeah.
I mean...
But I hope you understand my
I
general
understand your point.
And I don't know the Monsanto example, so... But I'm just
Okay.
trying to make a generalized point.
Okay.
Now, you may not agree with it, but I'm just telling you that nobody can prove that, because if you could prove it's called bribery.
Right.
The courts traditionally have viewed commercial speech as being less worthy of free speech protection, and the reason is because as consumer products, we have a certain reliance on how a product is presented to us for its use, its intended use, its safety. And so the Consumer Product Safety Commission basically is the kind of a cop on the beat, but we have a certain amount of reliability on the proper use of a product or how it should be consumed or used, and that's why commercial speech is pretty much held to a higher standard. Of course, even if you get a piping hot cup of coffee and it says this coffee is hot, and you go through the drive-through window and pay the McDonald's person for the cup of coffee, and you decide as you're going down the highway, as you're tuning the radio or you're turning on your cell phone, you stick it between your legs, and all of a sudden the plastic lid pops off on this styrofoam cup, and it spills out on your thighs, it's going to burn. But a woman still in Albuquerque still sued for over $1 million and won. Even though, man, this is hot coffee. Be careful. There's warning labels all over the cup.
They get even bigger.
And so, but it costs you and me money as consumers for those types of lawsuits. But anyway, that's that commercial speech, and they didn't feel like she didn't feel like she was fairly warned. Even though most of us really enjoy a hot cup of coffee. How many of you really enjoy a lukewarm cup of coffee? And that's your expectation of a cup of coffee when you pay for it. Can I have one of those lukewarm, bland coffees, please? So I won't burn my crotch or whatever. Of course, they consider activities that convey a political message or viewpoint to be symbolic speech worthy of First Amendment protection. Well, we also have something that is called obscenity. And the court applies what is known as the Miller test to determine whether or not something is obscene or not. And this is the three-pronged Miller test right here that's on this PowerPoint. Did I post these yet?
Yeah.
Okay, good. The first question is, in the Supreme Court when they're reviewing a case dealing with obscenity, first question is, does the average person believe that the material appears to prurient interest? Well, what in the wild world of sports is the prurient interest? What does that word mean?
It's gotta be some old English word.
No, does it basically cause you to think of something sexual when otherwise you wouldn't?
Oh.
I mean, does it arouse some sexual interest in you because you're happy to be observing this material? And otherwise you wouldn't have that sexual arousal. So that's the first test for the obscenity. The second test that the court uses is a three-pronged test. Is the material patently offensive? Just by its very nature, does it offend the normal person? And we're going to talk about the average normal person in a minute. Does the work lack serious literary, artistic, political, or scientific value? And so, basically, one of these have to be proven.
Just one?
Yeah, not all of them.
Okay.
Because, for instance, I can tell you, if you want to go back to the artistic one, in this third leg, the New York Museum of Art, there was going to be a display of Christ, and they were going to display Christ in a less than respectful manner, according to some of our values, if you're a Christian. And so something with regard to having feces on Christ's image. And they did it, and they wanted to display it in the spirit of being artistic. And so this word right here was the basis for that artist, or the New York Museum of Art, being allowed to display that repugnant piece of work. Obviously, it wouldn't be something that would meet that criteria, right? It wouldn't arouse sexual desires in you.
No.
But it certainly would have to be in this category. So
But the material that they were using itself was offensive. I mean,
but they were allowed to do it
because it was artistic.
because it met the artistic criteria according to the decision. So I'm just telling you, one of these have to be met. Let's go back to the average person. What's the average person? When the Supreme Court makes a decision, and this is a little bit beyond the scope of this course, but I just kind of want you to know this for your own observing pleasure as you observe court cases in the future. The court does take into consideration the community in which something occurs. Obviously, the Jesus matter was handled probably a little bit differently in New York City than it would have been in Carthage, Missouri. I mean, most people in Carthage would have never have stood for that, right?
Mm-hmm.
So they do take a little bit of that into consideration as far as what does the average person think in the community. And so they're there to kind of protect the average person. The Supreme Court really can't protect the extremes, can they? They shouldn't. But we'll talk about that a little bit later too. A public official in a libel or slander case must prove that the statements in question are false and that the defendants wrote or spoke the words with malice. We're talking about a public official that's being accused of something. And the person that's doing the accusing, either in writing or orally, is making those accusations with malice. In other words, to do that public official harm. And that's the purpose of those libel or slanderous statements. So that's also something that's being taken into consideration. The free exercise clause we talked about prohibits the government from interfering with an individual's right to practice his or her religion. The Supreme Court has upheld laws restricting religious practices that threaten the peace, order, and comfort of a community. There's that word community again. A lot of people want to know why Utah has certain practices. In fact, did you see yesterday, I think it was on Good Morning America or Today's Show, that this polygamist was there with his 3 wives and 24 kids? Anybody see that?
They've been hauling him around in the whole family.
But it's like they're all just happy as pig and slop. I mean, they're all perfectly content as one big happy family. And I mean, emphasis on big happy family. But I don't know what the polygamy laws are in Utah. I mean, I just don't know. But apparently they're legal for them. But that's their community, and apparently that's what's permitted. But they're not allowed here. Yeah.
They've been doing a reality show on them.
Well, I don't know all that.
Yeah, it's sick.
Yeah.
It should fall under freedom of speech, where it makes everybody sick.
The established, yes.
Well, okay, you know how you say Utah, the guy has 3 wives? Well,
They're from Utah.
Okay,
I don't
but
know
what-
what the legal circumstances are.
to say because in Missouri, should Missouri recognize that he's married? to
Well, there goes that
Full faith.
full faith and credit provision, right? I mean, that's something that'll have to be argued. I don't know if it's in the Constitution that you're only allowed to have one spouse or not. I mean, in Missouri Constitution, I mean, I don't know if the Constitution is that specific, but it is specific, I think in the 34th Amendment to the Missouri Constitution, that your spouse shall be of the opposite gender from you. But I think you're only allowed to have one.
But if these come from a state, they should recognize the states.
But I don't know if that's been tested yet.
I'm just.
I don't know, but that's a good point. I don't know if that full faith and credit's been tested in the state of Missouri yet.
Because I know it is with common law. Because we don't have a common law here.
Well, Texas has common law marriages, and when you move from Texas, your marriage is recognized as being whatever Texas agreed to with regard to your recognition, your legal recognition of your marriage, and they will recognize common law in Missouri.
Yeah.
In fact, my dad, I think, has a friend that has a common law wife. They were together for 40 or 50 years. That's usually the test of time test. You know, basically, if you walk like, talk like, look like a duck, you are a duck. And so if you act like, walk like, talk like a married couple, you're probably a married couple. And so that's kind of a silly test. But you bring up a very good point. In fact, I need to look into that. I'll give you an answer on that. Hold on a second. I'll get back with you. The Establishment Clause deal with the formal relationship between the religion and government, and at the very least, it prohibits the government, at the very least, it prohibits the government from establishing a national religion. Well, back before the Constitution, in 1787, the individual states did restrict religion in their states. In fact, if you are a Baptist minister in the state of Virginia, you better be watching out for the Anglicans and the Episcopalians, because that was really the formal religion in the state of Virginia. And Baptist ministers were in fact arrested for preaching the gospel. And so we decided in the Constitutional Convention that we didn't want that for our country anymore. So after all, that's one of the reasons that the Pilgrims came over, is to get away from religious oppression. The Lemon Test states that a law does not violate the Establishment Clause. So we're talking about being able to determine whether or not the government is tied to religion. And that's referred to as the Lemon Test in the eyes of the court. In the first leg, here we go with 3 legs again, just like we did with the Miller Test. The first leg has to do with, does it have a secular purpose? It neither advances, it being the government, neither advances or inhibits religion. And thirdly, it does not foster an excessive government entanglement with religion. In other words, if you can go into the relationship and you can separate the two, the idea of separating it may be problematic. But as long as you can separate it without not making it so complicated that the relationship between the government and the religion is so intertwined, it's mingled, then chances are it's going to be okay in the minds of the court. Bless you. But some people think that there are instances where the government does get entangled with religion, especially at the local level. And so we can argue that at length, but this is what the Supreme Court uses in making decisions if there's a violation of the Establishment Clause in the First Amendment to the Constitution. Some people think that the government favors private schools, religious schools, excessively because of the lack of availability or maybe quality concerns for public schools in certain districts. It's not uncommon for local school districts to have a contract with a private religious school for bus transportation. I mean, that's not uncommon. And the use of facilities and things like that. But those are usually separable. You know, they're not intertwined. They're not entangled with one another. You could separate the two. And they're contractual usually. So they're divisive in that way. It's not like they're institutionally joined at the hip, if you will. Interpretation of the Establishment Clause has been at the heart of numerous issues, so these issues are still being debated today, such as mandatory prayer in school and the federal aid to religious schools.